Hi, I'm Anna Burr with Burr Law, and I'd like to talk to you today about what happens when somebody dies and they have assets in a different state. People are very mobile these days, they relocate frequently. Sometimes people inherit property in another state. Sometimes people leave things behind and they just forget about it. Sometimes people draft a will and then they don't revisit it for a good 20 years or so. It is always good to revisit your will at least every 3 to 5 years to make sure that there are no major changes. And then sooner than that, if there have been major changes, the biggest one being if you've moved out of state. Probate is primarily handled in the state in which the person who died lives, more specifically in their county. But if somebody has real estate or other major property in a different state, then it's possible that you have to open what's called an ancillary proceeding in that other state. This can be a huge hassle for the family because they're trying to navigate attorneys and courts and property and everything from a distance. And sometimes it's easier to find a good attorney in some places than in others. So, uh, there are certain ways around it as long as we have the opportunity to plan ahead. The biggest one being that by forming a trust. If you have a will and then also acquire property in a different state, a trust allows your family to avoid having to go through multiple probate processes. We put everything into the same trust box, and it makes things much easier for the family. If you know somebody, or if you yourself are living in one state and have property in another, then it would definitely be a good idea to talk to a trust and estates attorney to discuss what your options might be to simplify that process for your family. I offer free consultations for the initial meeting and charge flat fee rates. I would be happy to help and take a look at anything that you may have. Thanks so much. Have a good day.